Rodriguez. As indicated, my name is Michael Cohen. I'm an administrative law judge from the Office of Administrative Hearings, and I've been asked to preside at today's argument. Could I take the appearances of the parties, starting with the respondent?
Yes, Your Honor. Peter Osinoff, appearing on behalf of Dr. Rodriguez, who is seated beside me. Good morning.
Good morning.
Good morning, Deputy Attorney General Carolyn Westfall on behalf of complainant.
Thank you. As the parties know, the rules for these oral arguments provide that each side is provided 15 minutes for their opening argument, with the respondent going first, and then each side is allowed 5 minutes for rebuttal, again with the respondent going first. And if he chooses, the respondent can then address the board directly, although Mr. Osinoff indicates that he does not believe respondent will be doing that today. So, with that said, and I will, if you do take your full time, I will let each of you know when you have 1 minute left on your allotted time. Mr. Osinoff.
Thank you very much, Judge Cohen, and members of the panel. Here is Dr. Rodriguez. It is now almost 3 years after his DUI. He's a big guy, but he doesn't have a drinking problem. If you look around the room, few of us in this room have had less to drink than Dr. Rodriguez since the DUI in March of 2013, almost 3 years ago. He was able to testify at the time of the hearing that there were 4 occasions when he drank socially after the DUI. One at a wedding, a couple of birthdays, including his own birthday on September 6, 2014. He didn't drive on any of those occasions. Shortly after that birthday in September of 2014, he received the medical board's accusation, and as he testified, he realized that any drinking that he does could affect his medical license. He was under no compulsion at the time, but that was a shock to him, and so he stopped drinking altogether. I asked him to prove it, to prove his abstention, and he signed up with First Lab, which is the medical board's contracted laboratory for performing random drug and alcohol tests. And all of his tests have been negative. He was testing for more than 6 months before the hearing, as was a negative test earlier than that during the course of an unannounced visit by the investigators in this case. The fact is, and the evidence showed, that Dr. Rodriguez had no drinking problem except on the night of March 19, 2013. It was a very light work week. He wasn't on call. He had planned a vacation, but unfortunately his wife's mother had just died 4 days earlier after a lengthy illness, and the vacation was canceled. Dr. Rodriguez is a very big sports fan, and in Blythe, California, a little desert community by the Arizona border, high school sports are the big thing. This was a game against Blythe's high school's arch rival in a public park. The JV game preceded the varsity game. So Dr. Rodriguez spent a long time in the parking lot where they could still see the game somewhat, tailgating with his friends. He had 8 or 9 Bud Lights in about 4.5 hours. Much has been made of the blood alcohol level of 0.17 by the AG's office. No doubt Dr. Rodriguez was quite intoxicated, and as he said, he knew it that night. Unfortunately, he got into a car, and that's why the investigation started, I believe, based upon the emphasis in this case on the blood alcohol level of 0.17. So the question was, does he or does he not have a problem apart from that single instance? And we have hearings for a purpose, to decide whether Dr. Rodriguez had a problem with alcohol that might impact his fitness to practice. The hearing in this case showed otherwise. From the moment of his arrest, Dr. Rodriguez was ashamed of his conduct on March 19th. He recognized he could never again drive after drinking, and he acknowledged his poor judgment that night, and he never again drove after drinking. And then he stopped altogether when he got the medical board's accusation. He has cooperated with law enforcement from that night forward. He arose late the next morning and only went to work when he felt fine to do so. The effect of alcohol had worn off. The ALJ himself noted that it wears off at about 0.02% per hour, so he wouldn't have been under the influence at all at the time he went to work. He promptly disclosed that very day to the chief of staff at his hospital, Palo Verde Hospital, and the chief referred the matter to the Well-Being Committee. Both the then chief of staff testified and the head of the Well-Being Committee testified. They both knew him well. They knew this was an isolated incident. They were very surprised by his bad judgment that night, which was completely out of character for Dr. Rodriguez, based on their years of knowledge of him and seeing him on call at all hours. There was no report, and never had been a report from any nurses or other patients that would indicate any impairment whatsoever by Dr. Rodriguez. Dr. Rodriguez acknowledged his guilt early on. He felt terrible about this. He enrolled in the first offenders program 2 months before he pled guilty and complied with all the terms of his criminal sentence. He only drank socially before his arrest. And then, once he got the accusation, he realized he couldn't drink at all. Without any compulsion of any monitoring, he was able to stop without a problem. He testified at the hearing that he never wants to drink alcohol again. He has just as good a time with his friends, he says, at parties or sporting events as without alcohol as he did with alcohol. He has an unblemished record other than that night of March 19, 2013. No malpractice cases, no discipline, no other arrests. He is the only native of Blythe, California, who ever returned to practice medicine in that very underserved community, and it's been over 20 years now that he has served that community. There are really 3 issues in this case, and may I inquire, Judge Cohen, what my time is?
You have 8 minutes and 40 seconds left.
Thank you. The 3 issues are: can the board discipline a physician for a single DUI with no evidence of impairment or no evidence of unfitness to practice? The second issue is, if the board can, should Dr. Rodriguez be disciplined? And the third issue is, if he should be disciplined, I would ask why, but what is the appropriate penalty, if any? Now, ALJ Hewitt, Judge Hewitt, a very experienced judge, found that Dr. Rodriguez could be disciplined under Section 2239 of the Business and Professions Code as using alcohol to an extent or manner dangerous to himself or others. But he also found that there was no unfitness to practice by Dr. Rodriguez and that he couldn't be disciplined for general unprofessional conduct. The difficulty is, if there is no evidence of potential unfitness to practice medicine, then we contend that he can't be disciplined under Section 2239. All of the cases under Section 2239 that have interpreted that statute, the Griffiths case, the Watson case, have held that in order to discipline a physician, the Constitution requires a showing of a connection, and this is true of all professions, a connection between the conduct of the physician and the duties, qualifications, or functions of a physician, that is, his potential unfitness to practice. Now, the Griffiths case has been thrown at me for years, more times than I can count. I represented Dr. Griffiths and argued the case in the Court of Appeal on his behalf. I might say that Dr. Griffiths is one of the most delightful, enjoyable people, full of stories that I've ever been around, and I enjoyed his company for years after that. But he enjoyed his good wine, and in 3 times in 5 years, Dr. Griffiths was convicted of driving convictions involving the use of alcohol. The court found in the Griffiths case that the legislature had made a rational determination that 2 or more misdemeanor convictions involving the use of alcohol constituted unprofessional conduct under 2239. 2239 states that not only excessive use or in a manner dangerous to others or himself can constitute unprofessional conduct, but that 2 or more misdemeanors involving the use of alcohol involves unprofessional conduct. And for many years, a single DUI simply wasn't disciplined, simply was not disciplined by the medical board. 7 years after the Griffiths case, in 2009, the board's newsletter, and that's part of this case in Exhibit L, stated the board's position at that time that it generally would not discipline a physician for 1 DUI unless there was evidence of an alcohol or drug problem. Now, the first clause of Section 2239, the use of alcohol dangerous to self or others, had always been there, but had always been considered to apply where the physician had a problem, where there was evidence of an impairment apart from a single DUI. Thus, in the Watson case, there were 4 uses of alcohol that got the doctor into trouble. And in that case, there weren't any convictions, so the doctor argued, well, you can't convict me, you can't find I was guilty of unprofessional conduct because I was never convicted. And the court said, no, there were 4 uses of alcohol which got you into trouble. That's enough for us to conclude that you have a problem with alcohol, and we can discipline you under that clause that says you're a danger to self or potential danger to self or others. So the medical board did not discipline single DUI cases. And then the Sulla case came along. In 2012, there was a case against a registered nurse. This is the Board of Registered Nursing case. One argument made in that case, and that involved a single DUI. One argument made in that case was that under the Equal Protection Clause, if doctors couldn't be disciplined for a single DUI, how can you discipline a nurse? And the court disposed of that argument, stating, well, 2239, which applies to physicians, had the same clause in it that we're disciplining the nurses under, and just because it has never been applied to a single DUI doesn't mean that it can't be applied to a single DUI, and therefore there's no equal protection argument. And based on that dictum, it wasn't part of the actual holding in the case, but based upon that dictum in the Sulla case, the Attorney General's office decided that this board can discipline doctors for a single DUI. Well, there's a problem statutorily because if you discipline a doctor for a single DUI, that would render the alternative clause in that statute requiring 2 or more misdemeanors in the absence of an impairment superfluous. That's not how statutes should be interpreted. Every clause in it should have meaning. The nursing statute did not have the 2 or more misdemeanor clause in it. And after all, what was the constitutional problem in Griffiths all about? If the argument would have been as simple as saying that a single DUI without more evidence of unfitness could be disciplined, then what's the constitutional problem of disciplining for 2 or more misdemeanors? So that raises the second question. We contend, though, that you can't constitutionally discipline Dr. Griffiths for 1.
Got a minute and a half
DUI.
left, counsel.
Minute and a half. Okay. The second question is, just because you can discipline, why do so? This is where A.L.J. Hewitt, the experienced judge, said, the purpose of discipline is only to protect the public. There's no basis for doing so here. This was an isolated occurrence. This was completely out of character for Dr. Griffiths. The public isn't endangered by for Dr. Rodriguez. The public isn't endangered by Dr. Rodriguez. Look at the steps that Dr. Rodriguez has taken since then to address what happened that night. The law rewards those who have taken steps to reform, to improve themselves. No penalty should be imposed. That was the court's position. And if a penalty should be imposed, what then? It is completely over the top and unnecessary to impose probation, as the Attorney General's office has argued. After all, the 2011 guidelines, which include discipline for 2239 violations, were rendered before anyone even thought of disciplining a physician for a single DUI case. The uniform standards for substance abusing licensees, which are argued in this case by the Attorney General's office, aren't applicable where there's no evidence of a substance abuse disorder, as here. So this case, without any history of any other problem, and with a single DUI, and with the steps taken by Dr. Rodriguez, bears no evidence that there should be any reason to penalize Dr. Griffiths in order to protect the public. No basis for public protection exists in this case. Thank you very much.
Thank you. Are there any questions for Mr. Osinoff from the panel members? Hearing none, Ms. Westphal.
Thank you. Ladies and gentlemen, the facts of this case are relatively undisputed. We know Dr. Rodriguez was arrested for a DUI back in 2013, and he later suffered a conviction for that. Through his own admission, he drank at least 9 beers on a weeknight after he worked when he knew he had to be at work the very next morning. Despite drinking that excessive amount of alcohol, he then felt intoxicated and chose to disregard the law and get in his car and drive, placing himself and others at risk. When he drove himself home, he ran a red light without stopping. And when he was arrested by an officer, his blood alcohol level was tested over an hour after driving, and it registered a 0.17, well over twice the legal limit, considering the fact that the ALJ pointed out 0.02% leaves your body every hour. And then he does, in fact, report to work less than 9 hours later, beginning to treat patients. We don't agree necessarily that he has proven he has no drinking problem. Counsel points out that much has been made of the blood alcohol level, and it is important to note that Dr. Rodriguez was able to drive his vehicle without too much problem with that high level of alcohol in his system. That is indicative of a regular drinker. So 9 beers in his system is a conservative estimate, but we'll give him the benefit of the doubt. So the first question, as counsel pointed out, is can the board even discipline a physician for a single DUI? Counsel argued this point at the hearing, and it was rejected by the ALJ. It was rejected because it was also rejected by the Court of Appeal in Watson v. Superior Court. This issue has been argued and argued and argued again. One need only read the Watson case, the bulk of the Watson case, to understand that the court has made painfully clear that 2239 allows various theories within it, various conduct that is deemed unprofessional conduct. And where the legislature has specified what is unprofessional conduct, the legislator has declared it's substantially related to the practice of medicine. No other proof is necessary. The board may discipline for excessive use of alcohol, dangerous to self or others. And because this issue has been decided by the Court of Appeal, I don't wish to waste any more of the board's time on this. So the next question is, should the board exercise its discretion in disciplining Dr. Rodriguez in this case? Counsel relies on a 7-year-old newsletter by the former chief of enforcement of the board, as well as his assumptions about what types of cases come to the Attorney General's office and what types of cases get filed on. He also argued in his papers that even the most egregious of DUIs only get public reprimands. What other DUIs, how other DUIs are penalized based on their specific facts is not relevant. Each case is taken on its own. And counsel's argument about what the board may or may not have done and what the AG's office may or may not have done is unfounded, unsupported, and quite frankly, it's outdated. We all know this is a new day in the light of the uniform standards that say that when a physician has been charged with an unprofessional conduct involving abuse of alcohol or drugs, they are presumed to have a problem. The fact that the uniform standards are in effect at all speaks to the fact that whatever had been done in the past wasn't achieving adequate public protection, and more oversight was necessary by the board. DUIs matter today. They are serious. Common sense tells us that they are extremely dangerous. But the reasons discipline is appropriate for this particular DUI is perfectly articulated in the Griffiths case that counsel referenced. The court in Griffiths discusses DUIs very specifically, saying convictions involving alcohol consumption reflect a lack of sound professional and personal judgment. They show a disregard of the physician's medical knowledge concerning the effects of alcohol on vision, reaction time, motor skills, judgment, coordination, and memory. They show an inability or an unwillingness to obey the law. They constitute a serious breach of duty to society, and they place themselves at risk. They also reflect a personal problem involving alcohol consumption. For all of these reasons, the board need not just sit back and wait until this particular physician's poor judgment and potential alcohol problem interferes with his medical practice and patient care. The board should impose some discipline necessary to protect the public from potential future harm. The board can discipline, the board should discipline in this case. So what level of discipline is appropriate? Well, when determining what level of discipline is appropriate, I think the board should look to its own guidelines. The guidelines themselves that have been adopted to further public protection. The guidelines themselves that list out with specificity for each violation what terms are recommended. And for the violations for which Dr. Rodriguez has been found, specifically state in the guidelines, 5 years probation. 5 years is the starting point. The guidelines should be followed not just because in and of themselves by disciplining a doctor it furthers public protection, but they allow for uniformity. They allow for deterrence, and that furthers public protection, which is the only reason to discipline anyone to begin with. Of course, the guidelines can be deviated from if there's evidence of mitigation and rehabilitation. And counsel has argued, as he did at the hearing, that no discipline is necessary because his client has provided some evidence of rehabilitation. It's true. His friends came in and said he's a good guy. We don't know he has an alcohol problem. He's a good doctor. It is true he provided 6 months' worth of biological fluid testing that said he had stopped drinking in the months leading up to his hearing. The evidence that he's shown of any rehabilitation and mitigation, however, how on earth does that justify a deviation from 5 years down to 0? Such a giant leap down to 0. And he argues that, well, this was just an isolated event. How do we know this is an isolated event? What do we know about this event? We know 9 beers. 9 beers, a 6-pack and a half in one sitting on a work night. Who does that? It is unlikely that he is the unluckiest person in the world. On the one night he does that, he gets caught. The best indicator of future conduct is past conduct. So what do we think he's going to do in the future? Well, most people do the same things over and over again. Maybe he means it when he says he's learned his lesson. Maybe he means it when this has gotten his attention. Though risking any discipline with his license was insufficient to get his attention back in 2013. But somehow this has gotten his attention. So let's hope he means it. But the board has to be concerned. And when the board is concerned, the best thing the board can do is just have some oversight. Let's make sure this doesn't happen again. Let's make sure he doesn't have an alcohol problem. Let's make sure this series of poor decisions he made that night don't continue to affect his personal life and then interfere with his medical practice if it hasn't already. It is always better to implement discipline before harm occurs, and for that reason, we're asking for some level of probation consistent with the disciplinary guidelines. Thank you.
Thank you. Do the panel members have any questions for Ms. Westphal? Seeing none, Mr. Osinoff, you now have 5 minutes for your rebuttal argument.
Thank you, Your Honor. Dr. Rodriguez never denied that he did wrong that night. He admitted that from the start, and that it was bad judgment that night. He was not on call. He was not working that night. But he shouldn't have done what he did. It was a crime. He's acknowledged that. But that doesn't mean that you need to discipline if there is no public protection purpose in doing so in this case, and that's exactly what Judge Hewitt found. There was no proof of any drinking problem in this case, and there is no presumption. The law does not make a presumption of a problem or presumption that Dr. Rodriguez has a problem. This is not a case under the substance abusing licensees, new uniform standard for substance abusing licensees. Those aren't applicable to the facts of this case. There are many DUIs, single DUI cases that have been investigated, and many single DUI cases reported to the board where no action is taken whatsoever. Just because this case went to a hearing and had a full hearing on the matter, and just because the board's investigation did not reveal any other evidence of a problem other than that night, and the testimony of the witnesses was found credible by an experienced administrative law judge, doesn't mean that just because this case went to a hearing that we have to punish this single DUI case. Others that have gone to a hearing for single DUI cases without evidence of a impairment have resulted in public reprimands. Generally two or more DUIs does result in probation. We don't have that here. The purpose of the investigation by the board is to uncover evidence of an impairment other than this single DUI. There was none. As Ms. Westphal said, the best indicator of future conduct is past conduct. We look at what Dr. Rodriguez has done in his past conduct. Absolutely nothing to indicate that he has any problem. The chief of staff said that 99-point-something% of the time I would hear about a problem if a physician had one, and he did not hear of one. People on call, people who called him in the middle of the night to assist them at C-sections, for patients who were in the ER in the middle of the night, never encountered any problem with Dr. Rodriguez. This is now more than 20 years of practice there without any other problem. So just because, assuming hypothetically that my legal arguments are wrong on the constitutionality issue, whether you could discipline for a single DUI, putting that aside, just because you can do it doesn't mean that you have to do it unless there is a public protection purpose in doing so. Not just a knee-jerk reaction, while we have a single conviction, then we're going to say, well, maybe it'll happen again, or maybe he'll endanger the public. That doesn't exist. That exists less with this physician than most other physicians in the state who haven't had convictions. So there is no reason on the basis of this single conviction to discipline Dr. Rodriguez, to protect the public. There is no protection of the public purpose exists in this case for that. Probation is simply way over the top and completely unnecessary in a case of this type. And thank you very much.
Thank you. Ms. Westphal, you have 5 minutes.
Thank you. A dismissal in this case would entirely defeat public protection, and it would do nothing to aid in Dr. Rodriguez's rehabilitation or even continued rehabilitation, giving him the benefit of the doubt. Yeah, there's no truer indication of rehabilitation than sustained conduct over a period of time. That's what we need. We need time. Time and oversight. Let's take a look just to be sure. Probation is absolutely necessary because Dr. Rodriguez needs time. Thank you.
All right, thank you very much. Mr. Osinoff, again, I'll ask if Dr. Rodriguez wishes to take some time to address the board directly.
No, but if the panel has any questions for me or Dr. Rodriguez, I would welcome that.
I see no hands, so the answer is no.
Thank you very much.
So this matter will now stand submitted. The record is closed. The panel, will now adjourn to executive session